Good evening, everybody. My name is Alina Sheltsova. Today is Wednesday, approximately 9 o'clock, and we are continuing our legally speaking seminars. Today we're going to be talking about changed country conditions and then exception to 1 year deadline for asylum filing. Generally, any applicant for asylum in the United States has to file his or her application within 1 year of arrival to the United States. And it does not matter whether the person crossed the border illegally or came to the United States via parole or on a visa. The 1 year deadline is pretty strict because if the person will not be able to provide any exceptions to the 1 year deadline, the person will not be able to receive asylum and as a result will not be able to receive permanent residency in the United States. The only other similar available relief that will be available is withholding of removal. But withholding of removal is actually a removal which is being withheld for a number of time. It does not provide for an opportunity to file for a permanent residency, and it does not provide for an opportunity to travel after the status is granted. Moreover, if the person will check his or her status through immigration 1-800 system, the person will hear that the immigration judge on such and such date ordered removal. So it's pretty important not to miss your 1 year deadline. What happens if the 1 year deadline is missed? Well, I would say that the person nevertheless has to try to file for asylum if he or she can present exceptions to the 1 year deadline rule. And one of those exceptions can be changed country conditions. What is it? Well, it's basically any material change in the country policies, practices, law, or general situation that affects person's eligibility for asylum. It can be that, for example, a person, let's take two countries from Eastern Europe. I'm myself from Belarus, so I'm comfortable with discussing those two countries. Let's say Belarus. There are many applicants for asylum from Belarus based on the restrictions of human rights that are happening there. And somebody who missed that deadline, will they be successful if they argue that the country conditions in Belarus changed? Well, it will be very difficult to argue this point with Belarus because Belarus remained approximately on the same level for a very long time, for decades, basically. But we can take another country, Ukraine, which just recently underwent through dramatic change in this country conditions. And people who, let's say, arrived in 1990s or 2000 something and missed the deadline for applying for asylum, now would be able to restore it based on recent change in country conditions. In fact, in 2014, in the end of 2014, there was an unpublished Board of Immigration Appeals decision acknowledging the fact of change in country conditions for Ukraine. And in my practice was a recent case where the deadline, USCIS agreed that the deadline should have been excused because of that change in country conditions. When the person is supposed to react to the change, can I just say, okay, in 2004 there was a change in country conditions, and now in 2014 I will be arguing this exception? Well, that's probably not going to be successful. And the reason for it is that the law still requires a person to react within a reasonable time. And reasonable time in each situation will be considered specifically specific to the facts. Let's say somebody got sick and they could not react quickly enough, or let's say that somebody was not aware of the country changed or was not sure what to do and things like that. Generally speaking, 6 months. If the person reacts within 6 months, this has been recognized as a reasonable time. If it's more than that, more than 6 months passed, then the person will have a harder time proving that the deadline was supposed to be met. What is the procedure? How does one do it, right? Well, it depends. If you have never filed for asylum, then it will be time to file the application with USCIS from I-589. There is a field there that's asking, are you filing your asylum claim within 1 year deadline? Yes or no? And the answer is no. If you miss the deadline, then you need to provide an explanation. And that would be the time when you argue whatever exceptions that are applicable to your case. If you already been through the immigration proceedings, let's say your case was with the immigration judge, and the immigration judge ordered removal, you lost your case, then you will have to go to the immigration court and file a motion to reopen. If you try to appeal the judge's decision, then you would have to go to the Board of Immigration Appeals and file your motion to reopen there. Based on changed country conditions. Important point here is that there is no limit on how many times you can file motion to reopen if you'd like to file for asylum based on changed country conditions. That is a very important point, because usually a motion to reopen has to be filed within a very limited time frame. In this situation, let's say your asylum case was denied 5 years ago, 10 years ago, and you are from Ukraine, and now there is a dramatic change in country conditions, and now you believe your claims will be viewed differently, and you'll be able to establish eligibility for asylum. So now would be the time to file that motion to reopen, even though the case was denied previously. That's how it works. What are the important things about country conditions? Whatever you file, whenever you argue that country conditions changed, you have to attach the research confirming that. Why it's important? You say, well, it's a common knowledge. Everybody knows in this country there was a revolution, or that, well, everybody knows about this now. But what if your case and your application will be denied? What are you going to do? You may appeal that motion to reopen that was not granted, and 2 or 3 years later, everybody will forget what happened in that country if you did not attach that research, those documents confirming the fact. So it's very important to document whatever change happened, even though you would think that it's a common knowledge. Basically, that one exception is a very powerful tool and very useful if you would like to pursue that route. There are other exceptions to 1 year deadline, not necessarily changed country conditions, like personal circumstances and other things, but that one is one that's quite commonly used. I will welcome your questions at through my website, www.shoutsova.com, and you can always give me a call at 917-885-2261. I welcome your questions regarding asylum. We do have a lot of materials about how to file for asylum, with evidence to present, and what exceptions to the 1 year deadline that are out there on our website as well. So thank you very much, and we all can meet next week.